I'm John Malcolm. I am the director of the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation, but more germane to the discussion today, I am the chairman of the Criminal Law Practice Group of the Federalist Society. I'm delighted that you all are here today. I hope you are enjoying a festive holiday season. And I think we are here today to talk about a very important topic. So in recent years, there have been a number of high-profile prosecutions of public officials. So names that come readily to mind are, former Senator and Vice Presidential candidate John Edwards, former Alabama Governor Don Siegelman, former Senator Ted Stevens and Kay Bailey Hutchison, former Congressman Tom DeLay, and of course, most recently, former Virginia Governor Bob McDonnell. Charges are currently pending against Texas Governor Rick Perry, it seems, for following through on his threat to veto an appropriation to fund an office being run by a district attorney whom the governor thinks had disgraced herself and should resign. And of course, it's also been widely reported that Wisconsin Governor Scott Walker is either under investigation or at least on the periphery of a criminal investigation for possible improper coordination with conservative advocacy groups. Here today to discuss this important topic so the topic today is really whether some prosecutors have gone too far in terms of initiating investigations and bringing charges against public officials for either political reasons or, more charitably, based on nebulous theories of criminal liability. Some public corruption prosecutions, such as bribery prosecutions for Duke Cunningham and William Jefferson, Cunningham of California, William Jefferson of Louisiana, prosecution of Jesse Jackson Jr. for misuse of campaign funds. These seem premised on conduct that has long been recognized as being criminal. But I'm not sure that the same can be said about the other cases that I mentioned. And here today, we're really very fortunate to have three panelists with a great deal of experience, both as prosecutors and in the private sector as defense attorneys. I'm going to now introduce them briefly, and believe me when I say far more briefly than each of them deserves, in the order in which they will speak. So our first speaker to my immediate left will be Todd Graves. Todd is a graduate of the University of Missouri and the University of Virginia Law School. And at University of Virginia, he also got a master's in public administration. He is a partner at the firm of Graves Garrett, where he specializes in white-collar crime investigations, and significantly, given our topic today, also political speech and election law. Like our other panelists, Todd has a wealth of public service experience as a prosecutor. He began his career as an assistant attorney general for the state of Missouri, and then later served as the Platte County prosecuting attorney, where he was elected and then reelected, before being named by President Bush the U.S. Attorney for the Western District of Missouri. Following that, we will hear from John Richter on the far left over there. John is a graduate of Emory College and University of Virginia Law School. He is a partner in the D.C. office at King & Spalding, where he specializes in government investigations. After a federal clerkship, John began his career as a state prosecutor in Georgia and then served as an assistant United States attorney in both Atlantis in Georgia and then in Oklahoma. During the Bush administration, John served in a variety of capacities. I had the pleasure of working with him in the criminal division of the Department of Justice, up to and including serving as the acting assistant attorney general in charge of the criminal division. And that was before he returned to Oklahoma, where he served from 2005 until 2009 as the U.S. attorney for the Western District of Oklahoma. Last but by no means least, we will hear from Ted Kang, who's in the middle there. Ted is a graduate of Yale University and Harvard Law School, and he is a partner in the D.C. office of Alston and Byrd, where he also specializes in government investigations. Ted spent several years as a federal prosecutor in DOJ's criminal division in both the public integrity section and the fraud section, and also served as an assistant U.S. attorney in the U.S. Attorney's Office for the District of Connecticut. During his time as a prosecutor, Ted investigated several high-profile matters, including the BP spill in the Gulf, the CIA's destruction of videotapes of enhanced interrogation, and also several high-profile public corruption cases. Ted was also the recipient of the 2012 Attorney General's Award for Distinguished Service. So with that, let's take just a moment to welcome the panelists, and then we'll hear from Todd. Sure.
Thank you for inviting me today. I really appreciate the opportunity. I was active in the Federalist Society at UVA when I was there, and one of the other members, I think, was Laura Ingram. So she's become a little more successful maybe than some of the rest of us. But I appreciate, again, being able to provide my perspective. I kind of bring the lunch pail Midwestern lawyer perspective. We deal with investigations specifically in the area of campaign finance is what I'm going to speak on. And these other topics are very interesting, but that's where my focus is going to be because I've spent a lot of time doing that in the last few years. And I'm really primarily going to focus on investigations because I think the investigations are a lot more pivotal in these circumstances than necessarily even the prosecution, because many times there doesn't end up being a prosecution. So it's the practitioner's world that I bring my perspective today. And in my experience, 8 years, I was the U.S. Attorney 8 years ago, and after that started this practice. Especially in the campaign finance scenario, it seems that there's sort of a government shoot first, ask questions later. There's a pervasive belief, and I think driven somewhat by the way it's talked about in the popular culture, that money is bad in politics and it should be prohibited. Whether there's a law or not is sort of an afterthought. It's bad and it should be prohibited. The terms we use, dark money, the gray money, these sorts of terms, I think lead to a certain conclusion. And the other backdrop piece of information is state laws are a mess. And we do a lot of state law work across the country. And the reason I attribute them to being a mess is because every state legislator thinks he's an expert on campaign finance. And every state legislator has something that happened to him or her in the last election that he wants to make sure never happens again. And so instead of having a uniform body like wills and trusts or something, some of these laws may start out uniform, but they get very specialized very quickly. And hard cases make bad law. Hard elections make bad elections law, in my experience. Another factor that's in the background, and I don't say this lightly, but ethics regulators are zealots for the cause. This is their life mission, and they're going to make sure that money does not influence politics. And so you've got this sort of, and this isn't a political deal. This is more of a philosophy outside of politics. They want to save the world from this. And when it gets to a prosecution level, a lot of times the prosecutor, especially again at the state level and even at the federal level many times, they don't have a clue about all the constitutional law, the campaign finance law, how it interrelates. They may have been doing a drug case last week, and this week they're doing a campaign finance case, and they treat them kind of the same. And there are some real constitutional protections that are in this arena that aren't necessarily in the other arenas. And I've had prosecutors tell me that. I've had prosecutors say, yeah, when I started discussing the constitutional harm of reviewing our donor records in a C4, saying, yeah, I don't know a lot about all that stuff, but we just think this is bad, and we need to look into it. And that's sort of startling in my shoes. Also, there's, and this is what people expect, and it does happen. Sometimes there is a political score to be settled, unlike in other areas. You don't often have a prosecutor, I've been a state prosecutor, federal prosecutor, saying, I'm kind of sick of that guy, that guy who committed this crime, or I don't like where he's coming from. They're players on the same stage in the political arena. Oftentimes the elected prosecutors or the appointed prosecutors and the politicians that they're investigating. So it creates an unusual dynamic. But yet there's often an ironic limitation from political accountability. Even though they're political actors moving something forward, there's this ironic thing. They have these boards that they hide behind, and they have these great names like up in Montana, it's the Commissioner of Political Practices that you have to deal with. And there's just one. And that gentleman's appointed by the governor. And he is somehow the arbiter of what is right. In Wisconsin, where I'm very active in a case, it's the Government Accountability Board. Who wouldn't want a Government Accountability Board looking out for them? And, it's a thin layer, and it's the Government Accountability Board. It's not someone who's grinding an axe, but if you ever get into discovering these cases, which we have in that case, you start to realize that there's a lot of axe grinding going on behind the scenes, even though there's a veneer of nonpartisanship. And the other thing about campaign finance cases that present a challenge is there's no premise agreement. Everyone agrees that fraud should be illegal. Everyone agrees that violent crime should be illegal. But not everyone agrees that campaign contributions should be illegal. And some people strongly agree with that, and some people don't. So there's this, like, two ships passing in the night on the subject. It's not, murder's illegal, but my client didn't happen to commit this murder. It is a situation where you're saying what you're doing, Mr. Prosecutor, is illegitimate. You should not be doing this. It's more inappropriate than what you claim my clients have done. So that creates a dynamic. And if you don't realize that dynamic is there, when you think about a campaign finance violation, ask yourself, who's the victim? Well, the public, but that's a pretty amorphous, and those are the same sorts of debates we hear when we talk about drug crimes. But on the flip side is, what's the value of a drug deal? And that's kind of hard to define. But what's the value of free political speech? And I think a lot of people would have disagreements over those issues. So you've got this very different worldviews and different interests colliding. And often these cases, they're frequently ginned up by political opponents, and then they're weaponized by the media and used against a candidate. That is frequently a scenario you're looking into. And there's little ability to challenge. Again, we're not talking about a prosecution. We're not even talking about a probable cause finding that you're debating. We're talking about an investigation. And if you're familiar with the Susan B. Anthony case, this is 3 steps before the Susan B. Anthony case. This is simply an investigation, but in a very highly charged environment. Those of you who've worked with the FBI know that there are 3 levels of investigation before it's even a grand jury investigation. So there's lots of things that happen before there's an official investigation. And if you're in state court, they're often litigated in state courts. The body of law is not uniform. You try to get into federal issues. There's federal abstention issues. In Wisconsin, we're handling several matters in state court. I saw Mr. Delacroix here and his firm. They're handling, for the same clients, they're handling some issues in federal court, and we've dealt with these types of abstention issues. And there is no quantum of proof, there is no burden of proof, there's nothing. This is just an investigation. And it has a tremendous, real chilling effect on the participants. There's pattern leaks that happen, maybe not in a federal grand jury, but certainly in state processes there's pattern leaks. And federal agents sometimes manage to let it slip. I had a case, federal investigation in a state in the Midwest, where 40 days before the election, there was an FBI agent wandering up and down the hallway of the State House, knocking on doors and saying, "Hey, where's the Lieutenant Governor's office? We have a few questions we need to ask him." And if that immediately ended up in the newspaper, and it's no surprise, I don't think, to that agent that ended up in the newspaper. He probably could have found the right office without asking around. So you're talking about a very charged environment. You have coworker fears. At the end of an election, suddenly all the lawyers are telling their clients, you can't talk to anybody who works on the election. You guys you have to keep to yourselves. That doesn't work. There are donor fears in campaign finance cases. Donors fear that they're being investigated or they will be investigated. They fear that their relationships and their communications. Who here hasn't written an email that you wouldn't really want to be read about on the front page of the paper? And those emails are gathered as part of the process. And if there's disclosure, there's retribution. We've seen real retribution against businesses for disclosure of their contributions. And the other thing is, it is a real harm in an investigation when you understand the way an organization works, its weak points, its strong points, its internal disagreements. I was thinking about this recently, and I realized that's why they have caucus elections in the Congress behind closed doors, because they don't want to expose those sorts of information. And that's why we have a freedom of association. That's why we have some of the rights we have in the Constitution. And courts are very reluctant to wade into these cases in a highly charged political environment. And the other thing that we've noticed is you have judges that are honorable, who are searching for the right answer, and you inject politics into it, and they just get goofy, and they start reverting to sort of what they would like to see happen rather than what should happen. We had a redistricting case, which I realize is a different kind of case, and sort of who was on what side of the different legal debates shifted in front of our very eyes in that case. So ultimately, you have a policy debate playing out in the context of a criminal prosecution in many campaign finance cases. And to use Wisconsin, which I've used as an example, in that specific case, they're looking into coordination between the governor and independent groups, Wisconsin Club for Growth, which is my client, Wisconsin Manufacturers Association, other groups. They're looking for coordination. And ironically, in Wisconsin, they tried to pass a law to basically the McCain-Feingold type law within 40 days of an election. They tried to pass a law, and it failed in the legislature. They tried to initiate a regulation, and they were sued, and they agreed in court that they would not proceed on that regulation or enforce that regulation on that very topic. So after those two things didn't work, they tried a criminal prosecution. And so we're playing out this very debate in the context of a murky law, and instead of having a civil prosecution, a regulatory matter, what have you, we have search warrants at dawn in political operatives' houses. And that changed the dynamic of the debate very quickly. As anyone who's done criminal prosecution, criminal defense knows that there's a real dichotomy between government resources and private resources. People hiring attorneys to fight these sorts of issues, they're in a real different position in a criminal case than they would be in a normal civil or regulatory case. And candidates can't or won't fight. They're trying to win the election. Oftentimes, these things seem to bubble up at really critical times for candidates. And the unfortunate thing about that is when the candidate won't fight, it sort of trains the accountability board lawyers that, if we bluff hard enough, we're going to get an agreement that we want, because they just want the wolf to pass their door. And fortunately, there are groups that are sort of speech purists that end up in these cases, like the Wisconsin Club for Growth, that do push back because they're not trying to win an election. As I said before, it's highly intrusive and overbroad in the political speech context. We're talking about search warrants. Search warrants are ex parte and in secret. We're talking about paper cases, and something that comes up in other areas of the criminal law is in search and seizure context, any document can be taken in plain view. So if you have any paper, anything in your BlackBerry, anything in your computer, they take it all, and they go through it. And if they find something else, they can prosecute you for that. And that's highly intrusive in this context. So there's no practical limitations on the seizure. There's no practical redress in many cases. It's very difficult, once they already have the information, it's very difficult to get in front of a court. Not that you can't, but subpoenas, those of you who've dealt with subpoenas are another thing. If you've dealt with federal grand jury subpoenas, they sign those ahead of time and put them in a drawer. It's not like someone really thinks through the topic. They pull it out of the drawer, the agent or the prosecutor puts some information on it, and they serve it. Bank records, no notice by law. They have all the bank records of your client, oftentimes unbeknownst to them. Email providers, no notice. I don't know whether that's by law or just practice, but you don't know that. They're reading emails for 3 years of an election cycle. And there's also sort of just a general cavalier attitude. We need to get this over with. We need to have some sort of clarity. We need to have some conclusion. The response is we're the government. We'll get to it when we get to it. What we're doing is right. And meanwhile, the house is burning down politically for this particular individual. Kind of trying to bring this all together from the investigation standpoint in campaign finance cases. There is a fortress federal. If you're dealing with the state entities, you have some redress opportunities. But with the federal entities, there's a real procedural difficulty because there's really no way to go back on them. There's no effective redress. The IRS case, we're handling one of the IRS cases, which isn't a criminal case. It's the case where certain Tea Party groups were targeted. We have the NorCal case, which is in Cincinnati. And in that case, we have an inspector general who, without a doubt, found that the dissenting groups were targeted by the taxing authority for their political speech reasons. They were asked ridiculous questions. They were hassled. That is beyond debate because their own IG has said that. But in our attempts to weave through the procedural roadblocks to seek legal vindication of some what we think are pretty important constitutional rights, it's nearly impossible. We've been able to thread the needle so far, but there were 3 cases. 2 of them were brought in the District of Columbia. One of them was brought in Cincinnati, and the 2 D.C. cases have been dismissed on procedural defects. And it's not because they weren't pled properly; they were well pled. And so the sum of it is, think of the Tom DeLay situation in one of these investigations. A win years later is hollow. The investigation is the harm. The allegation is the harm in a political context. And when you talk about these subjects with academics or even people who think a lot about it, who aren't sort of in that lunch pail world, the answer is always clear. Well, they can't do that. And from my world, in my context, in the real context, sometimes they can and they do, and it actually has an impact. So.
All right. Well, at the risk of being less lunch pail, one of the things that I want to sort of riff a little bit off of Todd's introduction on this investigatory risk and consequences that he has artfully summarized, and that's the question: is sort of why are we in that position? Why does the law seemingly provide a sufficient degree of discretion and latitude to allow these circumstances to happen, and for these consequences for political officials and players to occur, even in circumstances where ultimately there was not a crime committed? And I think one of the fundamentals to start from here, as we sort of try to answer, or at least get near answering the questions that are posed by John here to start us out, is trying to answer the question of what do we think the role of money should be in politics, because that is what is essentially at issue in every one of the campaign finance cases. It's what is at issue ultimately in every one of the public corruption cases, and the underlying question of the money is inevitably going to be the question in any of the cases, including even in the Rick Perry case, which obviously it's a different. There's not a question of bribery or any allegation like that, but the money there was withholding the money from a political office. And the relationship, of course, between campaign spending and politics is nothing new. As I prepared for this, I came across an article that recounted the first campaign for George Washington in 1757 for the Virginia House of Burgesses. And he lost that election. And he lost that election because he had no organization, and importantly, he spent no money. According to this account, he had most fundamentally erred in failing to provide alcohol to voters. And that defied the norms of the day. And I think that day lasted a lot longer than just the 18th century. But the practice of treating voters with food and alcohol was pretty routine at the time.
And we know one thing about our first president. He was a smart guy, and he learned from his mistakes. Because when he ran 3 years later, he plied the voters, and he spent 40 pounds to ply voters with rum, beer, and wine. In all, given that he was running, obviously, as a delegate in the House of Burgesses, they estimate that he basically provided a quart and a half for every vote he obtained, and he won by 70 votes. So I think one of the things, I offer that just to make sure that we recognize and put into context that the question of money in politics in all its various forms has been with us for a long time, and it is not an easy question to answer, and that many people have very reasoned disagreements and different viewpoints about it. And the role of the question of campaign finance has been around for us for a long time, and of course the irony of and the sometimes hypocrisy of politicians who push very hard for campaign finance reform is not only a present-day phenomenon. In President Teddy Roosevelt's 1905 State of the Union speech, he railed against the corporate campaign finance contributions. And of course, he was in that position because in the 1904 election, more than 70% of his election campaign contributions came from corporations. And so too, we know that therefore, that this question of money and its potential to corrupt has bedeviled our republic since even before its founding. And I think one of the things we can also see, of course, and it's starting particularly strongly during the populist and progressive eras, is this sense of growth of government and this growth of the federal state, and a belief and an increasing confidence in the ability of the federal state to control for perceived excesses. And that is consistent with various democratic theories of government and that apply to the public corruption standpoint, which essentially certainly inform a lot of the thinking in the public corruption prosecutions and the mindset oftentimes of prosecutors behind the scenes, as well as informing the thinking of regulators and informing the thinking of the legislative players who pass the campaign finance laws. And these, basically public corruption, the theory is that any public corruption permits certain individuals to exert an unfair influence over officials and political outcomes, and that in a democratic, the democracy is based on political inclusion and working towards a common interest, and therefore any unfair advantage through money, and particularly money that is corrupt, has an undemocratic effect. And I think we certainly see that as an underlying norm in the case law that gave rise to the honest services fraud statute, and the initial interpretations pre the Supreme Court decision in 1987 that struck it down. But of course, that law that I know Ted's going to get into a little bit more in detail, that law, which is based on the mail frauds, was originally based on the mail fraud statute and then recodified in 1988, is very much based on this norm of this sort of democratic theory of public corruption. And I think where this, bringing us back to the point about the investigations, the risks of the statutes like the honest services fraud statute and other statutes that get brought to bear, and just frankly the investigations themselves, which can be opened, obviously in theory at least at the federal level, the FBI in public corruption cases will have to, quote, predicate those investigations. At the state level and with non-criminal actors, it's not clear what predication they really necessarily are going to engage in. But at the end of the day, these statutes have a certain indeterminate quality about them. And part of that is derived from the fact that we aren't quite sure what the limits are for what constitutes public corruption, what is corrupt about money in our system and what isn't. I think we often can come to agreements about its core. The Supreme Court certainly was able, at least conceptually, to do so in the Skilling decision with regard to the honest services fraud statute. But as we move out from the core, it's subject to greater debate, greater fuzziness as to where the lines might be. And to be fair, I think we all have to acknowledge that some judicial interpretation of criminal statutes is a practical reality. I think the question of whether that indeterminacy is acceptable is ultimately the harder question. And you can easily see how you can come up with a sort of multi-factor balancing test as to what's acceptable or what's not. But in this context, where you're talking about investigations that can have significant political harm, and you're also talking about the question of due process and fair notice of criminal violations, the idea of a multi-factor test to try to determine what's acceptable or not is very unsatisfying. At the same time, of course, we all recognize that no one is really in favor of public corruption, or at least not publicly in favor of public corruption. And so I think the main criticism of the honest services fraud statute is a question of where of what is acceptable or not underneath that statute, and that I think is also gives rise to one of the things that I think we see in these cases, which is that and John Malcolm's early beginning statements are illustrative of it. He noted a couple of cases where, at least to John's mind, those seemed like pretty righteous prosecutions underneath this statute, and yet other prosecutions seemed perhaps a little more questionable. And this gives rise again to this question of what are the contours of the statute, what is acceptable, and what isn't. And one of the problems, of course, in that context is that oftentimes the immediate facts of a particular case are particularly compelling at a moral level. We don't like what we hear about a particular public official, and neither do the judges hearing this matter at the trial court level and at the appellate level. And of course, the risk of strong facts on a moral level is always an uphill battle for trying to suggest that a regime or a statute has problems under the circumstances. And so I think that individualization under this statute is another risk factor that is in play when we talk about the honest services fraud statute and other statutes where there's wiggle room in the political corruption context. I mean, I think one of the I saw a quote that I thought was helpful, and that shows what a sort of razor thin line we're walking in this world. And Judge Merritt recently, in a Sixth Circuit decision, wrote in dissent, "Subjective intent is the keystone of bribery. The influence of money in politics is growing by leaps and bounds, and the subjective intent of the public official is perhaps the last and only distinguishable feature between criminal quid pro quo bribery and permissible ingratiation. The exchange of money for a vote is a crime that threatens the foundation of democracy. The exchange of money for ingratiation and access is not corruption at all. Indeed, the exchange is so essential to the formation and the foundation of democracy, that it is protected by the First Amendment. We are left to distinguish the two as best we can by looking into the subjective intent of the public official. And by we, I mean the jury. And that brings me back then, I think, to where we started when Todd Graves sat down, which is, so long as we are in a position in which the laws are so broadly indeterminate that it is left to a determination about subjective intent to be defined by a jury, prosecutors and agents are certainly fully vested with sufficient discretion and a range of investigation to look into this conduct and to look broadly and to begin to define it in a know it when I see it kind of way. And that implication obviously is significant, and it means ultimately that in these cases the law as it currently stands and the choices that we've made so far politically is that ultimately to ensure what we believe are proper choices, the proper public corruption cases, the cases that are that seem impartial, that we are dependent truly on disinterested, non-political investigations conducted by persons with superb judgment. Given that that will not happen very often, it means that we get a product that we will be dissatisfied with. I'll stop there.
Well, John and Todd, you guys are very tough acts to follow. Thank you very much for those remarks. It's a privilege to be here and to serve on this very distinguished panel and to speak in front of the society. I do feel a little bit inadequate because I'm the only one on the panel who doesn't have the title of former U.S. attorney to my name. But I do hope to add some value to our discussion here today by giving the perspective of a former line prosecutor who was in the trenches, boots on the ground, and prosecuted these cases. As John mentioned, in my prior life before private practice, I was at the Public Integrity Section here in Washington, which, as many of you know, is a 25-attorney unit here in D.C. that specializes and focuses on the criminal prosecution of public corruption and campaign finance cases. So I want to start off with a boilerplate disclaimer that the views and opinions that I express here today are mine and mine alone and don't represent the views of Alston and Bird, my firm, or my former employer, the Department of Justice. You know, Todd and John really did a great job talking about the what and the why of the problem of over-criminalization of politics. I want to talk a little bit about the how. Specifically, I want to talk about the tools that are at the disposal of prosecutors today and the gray areas in the law that exist that prosecutors can potentially exploit in criminalizing what many believe to be legitimate politics. And since we're here in Washington and right across the street from the Willard Hotel, I think it's only appropriate to focus my remarks on prosecutions involving lobbying or lobbying type activities. Okay. Let me start with something that I think most people, most rational people, can agree upon. I think most people can agree that pure lobbying activities such as research, publication of white papers on the pet topic of your choice, is intrinsically good for society and should be fostered to help promote democracy. I think also most rational people would agree that pure bribery, right, a public official demanding and receiving payment from an individual to vote a certain way on a piece of pending legislation, that's intrinsically evil and should be criminalized. But of course, as with most things, it's that vast middle ground that's particularly tricky. And it's tricky because in order for lobbyists to do their job and to do their job effectively, they often have to cultivate personal relationships with public officials. And that involves not only making campaign contributions, but it also, on occasion, it means hosting events or providing gifts or extending other types of courtesies, meals, drinks, entertainment, sporting tickets. And recently, the DC Circuit in United States versus Kevin Ring, which was one of the last of the trials stemming from the Abramoff investigation, held that, and I quote, "The line between legal lobbying and criminal bribery is crossed when a gift is given or offered to a public official with a link to an official act," unquote. But that really begs a couple of important questions. First, what is official action? And second, how explicit does that link have to be between the quid and the quo? And I think that the answer to these questions, in light of recent developments, appear to be moving in a very pro-prosecution way that potentially endangers and potentially chills legitimate lobbying activity and delivery of basic constituent services. Let's start with the issue of official act. Official act is actually a statutorily defined term in the federal code. It is any decision or action on any question, matter, cause, suit, proceeding, or controversy, which may at any time be pending or which may by law be brought by any public official in such official's official capacity or in such official's place of trust or profit. Okay, it's a lot of verbiage there, but what's clear is, I submit, the plain text of that statute actually defines official act pretty narrowly because it has to apply only to a specific question, matter, cause, suit, proceeding, or controversy. But guess what? The definition of official act in recent cases appears to have expanded. Prosecutors have argued successfully that an official act now includes those activities that, quote, have been clearly established by settled practice as part of a public official's position. Okay? And as a result of that expanded definition, now activities such as setting up lunches or facilitating introductions or even attending a meeting all have been charged as official actions, even though those activities don't have a clear connection with a specific question, matter, cause, suit, proceeding, or controversy. Okay? And most recently, we saw this on display with Governor McDonnell. And in that case, Judge Spencer defined official act in his jury instructions as, quote, every action that is within the range of official duty. Okay? That's pretty broad. And I submit that interpretation almost reads out the question, matter, cause, suit, proceeding, or controversy language out of the statute entirely. And what's important to note is that this overexpansion of what constitutes an official act has real-life consequences. It has the potential to chill legitimate lobbying activity as well as the delivery of basic constituent services, right? If an official action can be read so broadly, then public officials are going to be chilled from doing things like facilitating introductions for lobbyists. And lobbyists are going to be chilled from asking for that. And doing so, in the end, has the effect of undermining the valuable line of communication that lobbyists provide between citizens and their elected officials. And by the way, those aren't my words. Those are the words of Judge Tatel, the DC Circuit judge in the Ring opinion. Okay? So then the question is, how did this expansion occur? How did it come to be? Well, actually, the ancestry of this expansion dates back exactly 100 years to a 1914 Supreme Court opinion called United States versus Birdsall. And in that case, Birdsall was a lawyer, and he represented certain people who pleaded guilty to unlawfully selling liquor to Native Americans. Okay. After those individuals were sentenced, clemency petitions were submitted by Birdsall on behalf of his clients to the president. Okay. Birdsall was eventually indicted and charged for having given money to two special officers for the Commission of Indian Affairs, which was an office within the executive branch's Interior Department. And in return, the officers gave false information to their boss, the commissioner, that supported the leniency petitions of Birdsall's clients. Now, Birdsall argued that the officers' actions were not, quote, official because there was no explicit law that vested the Interior Department to make clemency recommendations to the president. But the Supreme Court rejected his argument and concluded that, well, since the president is entitled to avail himself of the recommendations of anyone within his administration, the absence of any enabling statute was really not determinative. And then, here comes the language, even duties that are, quote, clearly established by settled practice can be considered an official act. Okay? That's the genesis of where we are right now. But the critical point is that in Birdsall, the activity that was performed by the special officers related to a specific question, matter, cause, suit, proceeding, or controversy. That is, they acted in regards to pending clemency petitions of Birdsall's clients. And that's very different, I submit, than the McDonnell case, where there was no specific question or matter that was pending before Governor McDonnell that related to Star Scientific, right? There was no pending bill. There was no grant application that was on his desk that related to the company. And the best evidence that even Judge Spencer noted in his most recent opinion and order that came out last week was that Johnny Williams had sent a letter to Governor McDonnell suggesting that the governor initiate a study of anatoblock at UVA and the Medical College of Virginia. But there was no evidence that the governor actually did anything to initiate such studies. So to use the Supreme Court's opinion in Birdsall as the foundational predicate for calling the alleged acts in McDonnell as official is quite troubling to me. Now, one other topic in my remaining time that I want to address was the other issue that I addressed, which is the link between quid and quo. What is the necessary proof to establish that link? The Supreme Court, in a case called McCormick that was decided in 1991, has held that when an alleged bribe is in the form of a campaign contribution, there has to be evidence to prove the existence of an explicit quid pro quo. Okay. This is distinct, however, from bribes that are paid in the non-campaign context. So when bribes are in the form of cash, meals, expenses, entertainment, that requires only proof of an implicit quid pro quo. Okay? And the Supreme Court has said that there's this distinction because campaign contributions implicate First Amendment rights. There's a desire to prevent the chilling of political speech. Okay? What exactly is the distinguishing factor between explicit and implicit is something that courts have debated for a long time and courts have struggled to pin down exactly. But what is clear is that one area is that in the explicit quid pro quo context, evidence of mere temporal connection between the alleged bribe and the official act is not enough to establish an explicit quid pro quo. However, when you go to the implicit quid pro quo, non-campaign contribution context, it is enough to rely on temporal evidence. Okay? And evidence of temporal proximity between alleged bribe and official act is a favorite technique of prosecutors. And it's been on display, rampant display in many non-campaign contribution contexts, especially most recently in the McDonnell case. And there's at least 3 reasons why this type of temporal connection evidence is so powerful. 1, it's because of the widespread use of emails and text messages today, all of which have clear date and timestamps. 2, it's an objective piece of evidence that can't be impeached, like a cooperating witness who's testifying to hopefully get his sentence reduced. And 3rd, it's easy to explain to a jury and to use it as proof beyond a reasonable doubt, right? Quote, "Ladies and gentlemen of the jury, 6 minutes after Governor McDonnell emailed Johnny Williams about a $50,000 loan, he emailed a staff member asking him to discuss the studies that Johnny Williams wanted to have done on a NATA block. What else could this be but a quid pro quo? Quid and quo, this for that. That's the line I always used when I was delivering my closing arguments. Simple to argue, simple to understand. Okay? But again, my view here is that the increased use of this type of temporal evidence to prove bribery also has the effect of chilling legitimate lobbying activity and the delivery of constituent services, right? Particularly when you pair that with the expanded definition of an official act that I discussed earlier. As a result, there needs to be further consideration, in my view, as to whether there should also be a heightened burden of proving explicit quid pro quo in the non-campaign context. And the danger here is very real, right? A public official who attends a nice lunch reception paid for by a lobbying firm might now be chilled from providing any basic courtesies for the lobbyist, including things like introducing the lobbyist to certain people, facilitating meetings, attending a phone call. And that chilling effect is gonna last for quite some period of time after that lunch. Okay? And that could be the case even if the lobbyist's position is something that the public official's constituents truly support. And what's worse, there is no safe harbor provision on how much time is enough time. What's temporal proximity? An hour? A day? A week? A month? A year? I don't know. Prosecutors know it when they see it, as long as they can argue it and prove it to the jury beyond a reasonable doubt. So these are, I think hopefully I put a little bit of gloss on some of the areas that I find particularly troubling. I mean, don't get me wrong. We all agree that corruption undermines democratic institutions and distorts the representative process. But the question is, have the scales tipped too far in favor of the prosecution to the point of chilling legitimate lobbying activities? And I would argue yes.
I think I'll stand so that I can make sure that I see everybody who sticks up a hand. If there's somebody behind that partition, if they want to ask a question, stick your hand out. Before I get to questions from the audience, I may or may not exercise moderator's prerogative. I just want to see whether any of our panelists want to respond briefly to anything that they heard their fellow panelists say. If not, we can get right to questions. Okay, Joel, go right ahead. Please stand up and speak clearly. You have a mic? Is there a mic? Oh, great. Perfect.
Why should anybody have any sympathy for someone like Governor McDonnell, which you seem to have, when this man took $150,000 from, until the day he was governor, a complete stranger? If you want to eliminate the problem you were talking about, don't take the gifts. Yet every time somebody introduces legislation in a state legislature or in Congress to forbid elected officials or policy-setting appointed officials from taking anything of value as a gift from strangers, they always oppose it. So in that sense, aren't they just getting what they deserve? Don't take the money, you don't get prosecuted. You can make all the introductions and facilitations and referrals that you want.
Well, I think I would respond to that. I don't know if this is on. I would respond to that by saying there may be laws that he violated, and actually he may not have, because the Virginia state ethics rules are pretty amorphous and lax. But I would think that at best, those receipt of all those gifts may potentially be a violation of some state ethics law. But to say that, to wrap that into a bribery case, I think is something entirely separate and distinct. And so what I'm saying is, I don't agree that the acceptance of all those gifts was appropriate and that he should have done it and that we should give our elected officials a free pass. It's just, I think it might be going too far to say that that was bribery.
Let me, there was a question over here, but I want to ask a question following up on that. I'm assuming, do you guys have anything to add to that? Okay, so let me briefly mention the facts of a couple of cases that will be well known to everybody. So one is the John Edwards case. John Edwards got charged with campaign violations even though there was never any evidence that any money from the campaign was used. So what happened in that case is a couple of very wealthy donors contributed hundreds of thousands of dollars to Riley Hunter, his mistress by whom he fathered a child, and to a staffer whom he persuaded in return for some payments to claim paternity of the child. And then another case involving someone from the opposite party was Alabama Governor Don Siegelman, who reappointed I think it was Health South founder Richard Scrushy to some hospital regulatory board. And shortly thereafter, Scrushy made a $500,000 contribution to a lottery campaign that the governor was running. Now, clearly unseemly conduct. It's very much along the lines of what Joel was talking about, to use John Richter's phrase, which I liked. It was compelling at a moral level. But where do you sort of draw that line between the unseemly and the illegal? Do you think the prosecutors more or less get this right? And is there some other mechanism besides a criminal prosecution that might be better at sort of exposing this unseemly conduct to public light?
I'll take first on the John Edwards situation. I don't remember exactly. It's been a while since I reviewed that, but my memory of that was the theory was that the donors paid off the individual who had his child, and if they had not given that money to the individual, they would have given it to the campaign or some.
Well, it was either that or certainly if this had been exposed without those payments, his campaign was sunk. So there was a relationship.
Right. But that, to me, that's, and I'm obviously no fan of John Edwards, but that's a perfect example of how we start to, that's horrendous behavior. And I think that the system, I think he would take the prosecution and not take the public wrath that he felt. Probably he'd rather have the prosecution. And I'm not sure that that was an appropriate place, especially with the stretch, because that stretch, anytime you stretch the law to reach someone who's done something very bad, he did a bad thing and it was inappropriate, then that gets applied down the road. That's now a tool in the toolbox that gets applied to a less obvious scenario, the old slippery slope argument. And I think especially in campaign contribution context, it's very easy to get down that slope.
Yeah, I think this gets back to the point I made that typically the compelling facts drive it. I mean, the ultimate question in that case was the money that was paid essentially to support the child, cover up the conduct, however you want to characterize it, was it truly a campaign contribution? I mean, the government's theory was essentially it would have otherwise been a campaign contribution. It was essentially, it was value add to the campaign because the campaign needed that to survive. But obviously, one could argue that it was many other things other than a campaign contribution.
Right.
You can see why these facts were sufficiently compelling in the first instance to lead to the opening of an investigation. And you can see why there would have been a great temptation, therefore, to potentially pursue it. And of course, the hard part in public corruption investigations is that particularly once they're public, they're obviously deeply injurious on the party being who's the target of the investigation, but they also create for the prosecutors and the Department of Justice a difficult proposition, which is it's hard to back away when you've opened and invested a lot of resources. Obviously, we would like to think that our Justice Department will do so in every circumstance where it is right to do so, and I'd be hard-pressed to name an official who would ever take a contrary position to that. But whether that plays out in every case and circumstances is very debatable. And so I think that's one of the dynamics in a case like Edwards. And obviously Edwards was ultimately acquitted of that charge. Yeah. The underlying immorality of the conduct, of course, remained hanging out there. He was severely criticized in reputable and less reputable public publications over a long period of time. And so certainly in terms of the political consequences for the activities that were received, there was a significant sanction for him, a sanction far beyond probably ultimately what was necessary to, quote, chill the behavior. And I think that's how I would size it up.
Yeah, I'll add one more comment to that. I do think, John, as you mentioned, the lack of sort of a middle ground, a middle solution, makes cases, and I'm going to use McDonnell again, very tough, because clearly the gifts that he received were pretty gross and pretty egregious. And I think everybody understands that. I think people understand that that was wrong. The fact that the only vehicle, though, for holding him accountable was a criminal prosecution, I think that in a certain way was an overkill for him. And because it was the only forum to which his actions were going to be ultimately be held accountable, I think the jury that was hearing that case, they felt compelled to convict him and hold him accountable for something. And prosecutors oftentimes, when you have good cases like this, in terms of really, really egregious quid, but weak on the quo, you hammer away at the quid and you keep sort of trying to inflame the passions of the jury and say, well, here's our elected public official who's driving a Ferrari, who's getting a Rolex watch for free. How could he have not expected that he had to do something in return? That's the prototypical argument, but I think that elides and sort of masks the argument that the requirement that you need to also prove a quo on the back end. Now, what needs to be done to rectify this, I don't know. I mean, maybe I think it's something that has to be considered on the state end. Greater transparency is going to result in greater public accountability. It's also gonna force people to think twice about accepting certain gifts. So perhaps some type of uniform rules on state ethics laws, perhaps a state ethics commission that has greater powers to investigate and issue some type of punitive measures in these instances. That's all potentially something that could be considered for reform. But I do think some type of middle ground in these types of cases where there's really strong evidence that there were egregious gifts given, but very weak evidence on the official act. There needs to be a middle solution to those cases.
Go ahead, Todd. Yeah.
And here's why it matters, because again, we're talking about individuals and things they did, but why does it matter if the right thing happened, if John Edwards should have gone through that? But in law school, we were all taught that the state is the common law. The feds are limited powers. They have statutes. It's all very clear. You understand it. But if you would go to a fraud jury instruction, for instance, in my state, in the state of Missouri, it is very detailed. It's a patterned instruction. The charging for stealing by deceit, which is fraud, is very detailed. If you don't follow them, you can automatically be overturned. And then take out the wire fraud statute. If you still have any of those red books with the U.S. Code annotated, and flip it open to the wire fraud section, which honest services fraud kind of grew out of the wire fraud section. And there are volumes trying to define what a corrupt purpose is. And they've written out simple common law elements. I think actual harm, correct me if I'm wrong, is no longer in the wire. It's easier to convict someone of wire fraud than to bring a case against someone for common law fraud in civil court. It's easier to convict them in federal court, and you end up with the situation that we were talking about before. Everything's criminal if you want to work hard enough, or it's at least vague. And the investigation, how many criminal trials do we have? We don't. If you're charged, you're typically going to try to accommodate that. So the more you expand and the more you make it unclear, the more likely that not the John Edwards, but some guy down at the DMV who does something that's not anywhere near these kind of weighty issues gets charged and convicted, or he doesn't get convicted, he pleads because he can't afford to try the case and ends up going to prison on something that's pretty unusual.
Do you think after the McDonnell case that a politician is going to be able to rely on a defense when he does something for a friend or for a major donor, saying, oh, these were just standard constituent services? Or do you think that, setting up a luncheon, sending something to a staffer saying, gee, will you look into it, the kind of thing that traditionally people used to think of as constituent services, do you think that distinction is now gone?
Well, yeah, I mean, I think you can still deliver constituent services, but now they're going to have to think twice about, well, what did I receive?
Right.
I mean,
From-
to be fair, I think the vast majority of public officials and political officials know that they probably should not have a wedding paid for.
That's true.
They probably should not have a gold Rolex. I mean, and certainly not, be photographed wearing it. I mean, look, one of the age-old jokes as a prosecutor is, look, we only catch the dumb criminals. We don't catch the smart ones. And there's some truth, obviously, some underlying, perhaps, perverse truth to that. But I think that the fundamental question really is we can often agree on come to agreement on moral norms. I think what we're trying to talk about here today is the clarity of where criminal sanction and what is notice, given the circumstances that that money inevitably is an important part of the political process, and arguably an increasingly important. One might argue, and there's certainly sort of a contrarian view of campaign finance that suggests that the low-level limits on campaign contributions actually incentivized greater campaign fundraising, because you're constantly having to get just a little from a lot of people. You have to therefore devote much more time to getting out there and doing that, and less time focusing on your actual official duties, and that creates other things. And so, as one of the interesting parallels is, as we have seen increased campaign finance regulation and an increased reliance on federal criminal prosecution to combat public corruption, I don't think anyone would suggest we have seen less corruption or less money in the system. And that really raises fundamental questions as to whether our solutions are well tailored to the goals that we're seeking.
Let's make the question a little harder, not a Rolex watch for a governor. But let's, as the federal government increasingly becomes more involved in other aspects of our lives, like healthcare, what about your biggest donor whose daughter has leukemia and needs a certain kind of bone marrow transplant? And he comes to you, and you're an elected official, and you call the czar of medical treatment, whose
budget you control.
Yeah, right, and say, I'd like to see this happen. And it's kind of on the edge, and it happens. I mean, as we expand these definitions, now if someone doesn't like that, that's a crime.
Good point. There was a hand up over here.
Paul Jossi, thank you. One of the refrains that we commonly hear, at least from the left, at least in the campaign finance arena, is, oh, if we only had the taxpayers funding our candidates, then all of this corruption would go away. And I'm wondering what any of you would think about, would that actually happen, the diminution of private money in campaigns? How would that affect corruption, prosecutions, or just corruption in general as quid pro quo? Thank you.
Well, as far as if only questions, what's the saying? If a frog had wings, he wouldn't bump his ass hopping. If only we have the Constitution, and even if we limit contributions to candidates, we still have a constitutional right to spend money independently however we want. So it's not going to affect. I think it's what goes to what John said. It's just going to drive that money into the corners. There's still going to be money spent. It creates a debate. It creates a robust debate. I've seen the numbers that show we spend less on a political campaign, on all the political spending in the United States, and I'm going to get this wrong, but it's far less than what we spend on marketing toothpaste every year. And unless the Constitution is changed, any kind of state financing, they're not even accepting the presidential candidates. President Obama, I believe, is the first one, didn't even accept public financing because he could do it better another way. So I don't see that as working personally.
And I think there's also, of course, concerns that flow out of that, which is you now have really the government deciding who are legitimate candidates and who are not. And that obviously can have a chilling. It essentially levels the playing field, notwithstanding that people in society may not want the playing field to be leveled. In other words, and when you talk about, we like to think about this in terms of the two main political parties, but there are other parties out there, and where are you going to start drawing that line? And if they're equally as financed, you got some outcomes there that may be less desirable. Now, maybe the proponents are interested in some of those other political parties, but that's another question for another day.
Stuart?
Hi, I'm Stuart Taylor, freelance journalist. I'd like to ask whoever wants to answer, not excluding you, John Malcolm, how new or growing is this phenomenon of criminalization of politics, how are defined? Are we seeing a lot more of it than we did 10, 20, 30, 50 years ago? And I'd like to also ask about the same question with regard to a subset of that, a case like Scott Walker in Wisconsin, where there's a lot of evidence that the prosecution is motivated not just by the things that traditionally motivate prosecutors, but by the desire to take down a political enemy who he's mad at for reasons having nothing to do with criminality. Are we seeing more of that? Does that fit the Perry prosecution, for example? Or is this just politics as usual going back for generations?
I have my own thoughts, but go right ahead.
From my viewpoint, the things that have changed, why it's not just as usual, I think there were three different issues there. One is the single-purpose entities, the government accountability boards that are no longer under political control, the Commissioner of Fair Political Practices. Those entities, I think, are relatively new. And, if all you have is a hammer, everything looks like a nail. I think that that's the way they see the world. And it also is about bureaucratic jockeying, budget, position, authority, accolades. They want to nail some scalps to the wall so that they justify their existence. That's just natural. So I think that's different, the single-purpose entities. The other thing I think is different, and I don't have anything to base this on, but I don't believe, and you'd know better than I would, but I think public corruption and U.S. attorneys' offices took a very distant backseat to the FEC and campaign finance enforcement historically. And I think in the last few years, they've sort of come out from behind that and decided they're going to enforce some stuff independently and maybe ahead of the FEC is what appears from my viewpoint. I don't know that for sure that's true.
I'll address that in a minute. The public integrity section and really enforcement of political corruption cases really sort of raised and took off after the Watergate scandal. That was when the public integrity section was created. And then you had an expansion of, as John was talking about, the honest services fraud statute that really took off after it was codified by Congress, I think in the 1980s, that wire fraud and mail fraud includes the theft of honest services. And this was sort of the period in the 80s until the 2000s when the Supreme Court dialed it back in the Skilling opinion to say that the honest services fraud statute cannot be used to prosecute cases where public officials simply concealed a conflict of interest, but has to relate there has to be evidence of kickbacks and bribes. So it's sort of between in the 80s, 90s, and early 2000s, you saw a spike in the number of political corruption type cases because really the Justice Department had this blunt instrument that it was wielding, and the honest services fraud statute was defined and interpreted very broadly. Then I think you had a dialing back with post-Skilling, But now, as I sort of mentioned, there are other areas, other gray areas that justice and the courts have now been interpreting slightly more broadly to sort of bring up and give more weapons for prosecutors to use in bringing these cases. So there's been ebbs and flows, but definitely right now it's back up on the rise.
Yeah, I mean, I think one of the things to keep in mind, Stuart, is that from the Justice Department's perspective, I think beginning in the 70s, there was an increasing perception that state and local law enforcement could not take care of public corruption. They either lacked the resources or they lacked the willpower for various reasons to combat it, and that obviously was effectively disenfranchising the citizens who lacked essentially the same access as the corrupting persons were able to get, and that came obviously was part and parcel of a whole bunch of changes at the federal level coming out of that era, Foreign Corrupt Practices Act, other areas where we were looking at what we saw as corrupt activities in the political realm, and of course the creation of the Public Integrity Section in the Criminal Division was part and parcel of that. I think the more recent, but the underlying honest services fraud statute had been used, albeit fairly sparingly, just like many of the federal laws had been used fairly sparingly until really post 1968 really has a strong growth in the department's criminal jurisdiction. And so you have the precursors to this law, this intangible rights theory, this right to honest services that go back. I think there's a seminal case in like 1941 out of the Seventh Circuit that involved Governor Otto Kerner and some bribes related to I think racetracks, horse racing, and there he was evidently paid bribes, if my memory serves me, in exchange for the award of these racetracks, and the award of the racetrack contracts actually. The state of Illinois didn't lose any money as a result of that. Arguably, they made more money. These guys evidently were perfectly good at running racetracks. And so their defense in part was there really was no actual loss to the state. But that argument did not carry the day, and that argument was reinvigorated then as public integrity and U.S. attorneys' offices increasingly saw this. And let's face it, when a U.S. attorney's office has a big case against a big target, it is, and it is being, as Todd put it, weaponized by the media. I mean, it becomes big news, and that can be captivating, and has obviously, it can be destructive, too, for all the parties involved, depending on the circumstances. And you can certainly see terrible consequences from these cases when things go wrong. Obviously, the Ted Stevens prosecution is a perfect example of circumstances. No one would suggest that the outcome in that case for either the defendant or at least some of the prosecutors involved was a satisfactory one, and so this is high in a lot of these cases with the most senior officials. It's high risk, high reward, and that has a natural chilling effect on some prosecutions. The one thing I certainly told would always lived by when I was an AUSA and a U.S. attorney, but particularly as U.S. attorney, is at the end of the day, when we bring one of these high-profile cases, the reputation of the office, and frankly, my reputation as U.S. attorney is on the line. And that's not the case, obviously, in more routine criminal cases. So it's not to say that there are no no controlling factors or chilling factors on prosecutors in these cases. But they can be where the facts are compelling and where there is a perception that there's not adequate controls at the state level to deal with it. There is a lot of desire and belief that it is the role of the Justice Department to take care of the situation.
Well, let me jump in. Actually, I will offer some comments, Stuart, because you were talking about whether or not there's an increasing trend in politicization of public corruption prosecutions, and these guys have all commented on prosecutions at the federal level, specifically by the public integrity section. And I would say that people in the past have tried to throw mud at the Justice Department and accuse the Justice Department of politicized prosecutions. Don Siegelman certainly did that. John Edwards certainly did that. And I would say that that mud has, for the most part, not stuck. It might have stuck in the Ted Stevens case, except for he was a Republican senator being prosecuted by a Republican administration. I do think that charge may very well have some currency in the state level. The political dynamics are very different. You are talking about elected officials. You are talking about elected officials within the state at a high level where they frequently have a personal and professional history with each other. Sometimes you're going to have a Democratic governor and a prosecutor from a heavily Republican district or vice versa. And so you end up having situations like the case that you've been investigating and doing some excellent reporting on, where you have a Democratic DA investigating a Republican governor. The same DA's office in a very heavily Democratic district in Texas is the same office, not necessarily the same DA, that prosecuted Kay Bailey Hutchison, Tom DeLay, now Rick Perry. Now, these prosecutions may or may not be politically motivated at the end of the day. Certainly the Tom DeLay case and the Kay Bailey Hutchison case, those went down in flames. But when you have a heavily charged political environment and a high-level official of one party being investigated and prosecuted by a local elected official from another party, you're leading with your chin. And that it's a little harder then to distinguish what's a righteous prosecution from a political prosecution, particularly as the facts become a little bit more nebulous and sort of in the gray areas that Ted was talking about. So I had Hans down here, and then I get to you. Microphone? And if anyone over here wants to raise their hand, I'll work my way over. Over here. Over here.
You all may. Sorry, I'm Hans von Spakovsky. You all may have answered this question, but I'm wondering whether you all have observed and would agree that in the last 5 years there's been a lot less sensitivity to First Amendment concerns in the public integrity section, and I wonder whether that's can be related to the change of personnel there. And the reason I ask that is that the person who used to be in charge of election crimes, which included campaign finance violations, was a longtime career guy who'd been there for 3 decades. I know him, and he was extremely sensitive to and understood the First Amendment implications of campaign finance prosecutions. He left and retired shortly after the Obama administration came in, and I have not seen the same kind of sensitivity to those First Amendment concerns. I wonder whether you agree with that and whether that is part of the problem that has then translated down to the U.S. Attorney's offices because public integrity is supposed to approve those kind of prosecutions.
Well, I think, and I'm going to be speaking sort of on behalf of my former colleagues here, and I'll tell you, when I was a prosecutor there, we would always be sensitive to First Amendment issues and concerns in the campaign finance cases, as well as in the sort of the traditional bribery type cases. I'm going to piggyback off what John said earlier. By no means, when we're talking about politicization of the over-criminalization of politics, what I view that is the expansion of criminal laws into political activities, as opposed to the politicization of the prosecutorial decision-making process. Because I will tell you, to a man and woman at the public integrity section, they truly look at the cases from perspective of the facts and the evidence that they could prove at trial and that have been obtained during the course of the investigation. And I will tell you, from the line prosecutor side, which is where most of the decisions and recommendations are made on whether to bring a case or how an investigation should proceed, politics does not enter into that discussion at all. So to the extent that there has been a shift in policy, I can't speak to that. I don't know why that's the case. I do know for a fact, though, that if there has been a change, that isn't something that now the public integrity section feels that, you know, there's been a change of administration and for whatever reason, we're going to take a different approach to First Amendment issues. I think the whole purpose, in fact, of the creation of the public integrity section was to create a standalone unit that could go to various jurisdictions all over the country and be devoid and be neutral and non-biased and bring an unbiased gloss in investigating cases which have a political bent. And there was the concept that that state prosecutors, for sure, but even local U.S. attorneys' offices where there might be a politician who is a federal official, there might be, if not an actual conflict, an appearance of conflict that could arise at some point during the investigation. The whole purpose of the public integrity section's creation was to sort of make sure that that did not occur. So I don't think that there's any politicization within the section, at least that I know of, on the issues that you speak of.
You know, from my standpoint, I think anecdotally, I don't know the personnel there, but I think I've seen exactly what you're saying. But I would also agree there's two sources of I think over-criminalization in the political process. I do think at the state level there are political actors acting for political reasons. The entire time Scott Walker's been governor, there's been a secret investigation of him. The entire time. It's been like 2 different investigations. He's had the same guy investigate him since before he was governor. And, you know, I would question that. But I agree at the federal level, your danger isn't I'm a Republican and that's a Democrat and I want to get him. Your danger is I want that career case. The most dangerous place in the world is between an agent and an AUSA and their career case. That's a bad spot to be because there are different motivations. I one time tried to get the FBI, when I was U.S. Attorney, to look into something for 2 years. No dice. It was on the cover of the local newspaper, and they opened an investigation the next day. Same issue. And the accolades, these are people that they like to go to the U.S. Attorney's conferences down at the NAC. Oh, yeah, I've got that big case. And, it's just there's a different kind of motivation. And it's been alluded to several times. When you get a big-time name and a big-time case, we represented Zach Scruggs in a completely different kind of case down in Mississippi. And the prosecutor, when we were talking to him about settling the case, he was discussing the book that he was going to write. And he wrote the book. He left shortly thereafter. This was a career guy who I'm not questioning his judgment, but that's in the mind. And so there is a motivation at the federal level that is dangerous, but it's not, I'm an R or a D, and they're not my brand, I don't think.
Tom? Yeah, I just to echo a little aspect of that, which is, I think it's absolutely true that in my experience, the vast majority of prosecutors who I encountered during my time at the department, and even since that time, are not motivated by sort of traditional partisan labels. I can think of an exception, but I won't bring that up today. But I do think that there is a natural tendency when you are in a particular subject matter to become very cynical about the process. So I think one of the things that you see with public corruption prosecutors, I think you see it with federal prosecutors generally, but I think with public corruption prosecutors particularly, is that they are very disgusted by what they see about the money, how the money flows in politics. And they see a lot of conduct that they don't ultimately pursue because they decide ultimately the law or the facts themselves are not sufficiently compelling or whatever to bring that particular case or to open that particular investigation. But the net weight of that experience over time makes them far less open-minded to the idea that this is speech and that these people are truly trying to get the word out, and much more of a mindset, I've seen the money, and this is really corrupting in a lot of ways. So I think that is a real natural tendency that can occur. It's certainly not, it plays out different ways in different fact patterns. But I think that's a different motivation than a partisan motivation in terms of perhaps being a little less sensitive to a purist First Amendment view. And then I think it's also important to recognize that the treatment and the right and the First Amendment and the scope of the First Amendment, I think we can go back to basically the early years of the Republic and see that courts themselves have not always been particularly respectful of the breadth of the First Amendment, as I think probably many in this room might be inclined to see it. And so to the degree that anybody is less than fully respectful of it or of its in its broadest interpretation, while we may disagree with them fundamentally, they can join a long list of distinguished jurists since the early 19th century who have certainly upheld all kinds of laws that I think we would find very, clearly transcended basic First Amendment rights.
At the risk of blowing slightly past the witching hour and not seeing too many people getting up yet, you've been very patient, so I'm going to call one more question over here, and then if we can have a short question and some quick answers, we'll wrap up then.
Hi, Brent Gurney. I've been both a federal prosecutor and currently do criminal defense work. It seems to me that much of what you have said here today about politics in the criminal law could be applied to almost any aspect of criminal law enforcement today. Indeed, a title for this could have been the overcriminalization for everything. Because the things that you have talked about here, I see across all the industries, energy, healthcare, almost every single one of them, we see broad use of wire fraud, mail fraud, indeterminate statutes, zealous prosecutors who are looking for a career case, who may be acting from self-righteous motives. Doesn't mean that they're overzealous. And I want to know if you, what your thoughts are about whether this is part and parcel of a much larger problem.
Gentlemen?
To a large degree, I agree with that. Especially, I've done some work in the energy industry, and you do see that. I think the wire fraud, the mail fraud, as I alluded to before, those are really broad. We could go through the code and some things. I don't know what's my personal opinion, what's not. Some things I like, some things I don't like. But I think what makes, especially the campaign finance aspect of political activity, is it's so fundamental to our government. And I may not agree with all the regulations of an EPA, but I understand that I agree with the goal. Regulating political processes, how we choose our leadership, I kind of get off the bus on the whole goal there, because I don't think it's workable, and I think someone's always going to get an advantage. And that's what really separates this for me.
Yeah, I would agree with that, and I do think you're seeing overexpansion in many areas, including, for example, the Foreign Corrupt Practices Act, and you're seeing broad extraterritorial reach for conduct now that's entirely overseas with barely a nexus in the U.S. But I do echo what Todd says. In the lobbying activity context, as I mentioned here, you're really dealing with interpretations of the law that has the very realistic impact, potentially, of chilling legitimate lobbying activity, legitimate delivery of constituent services, all of which is the bedrock of this country's democracy.
I want to thank you all for coming and wish you all a very happy holiday season. Please take a moment and thank our panelists.